Hello, and welcome to Vandeventer Black's Technology Roundup podcast. I'm Jonathan Gallo, and I'm an attorney with Vandeventer Black. Today, we're going to talk about the Department of Justice's announcement about a new civil cyber fraud initiative and what it means for federal contractors. Recently, Deputy Attorney General Lisa O. Monaco announced the Department of Justice's new Civil Cyber Fraud Initiative, which is aimed at combating new and emerging cyber threats to the security of sensitive information and critical systems. This initiative will be led by the department's Civil Division Commercial Litigation Branch Fraud Section and is a direct result of the department's comprehensive cyber review ordered by Deputy Monaco last May. The initiative will utilize the broad civil enforcement provisions of the False Claims Act to pursue cybersecurity related fraud by federal government contractors and grant recipients. The False Claims Act is a powerful tool used by the federal government to redress false claims for federal funds and property involving government programs and operations. The False Claims Act has whistleblower provisions which allow private parties called relators to bring legal actions on behalf of the federal government. These actions are called key tam actions, and it allows them to pursue fraudulent conduct and share any recovery while protecting whistleblowers from retaliation. In its announcement, the Department of Justice also called attention to where whistleblowers may report fraud, waste, and abuse mismanagement on their website. According to Deputy Monaco, the government intends to pursue companies, those who are government contractors who receive federal funds, when they fail to follow required cybersecurity standards. According to the department, the benefits of this initiative include building broad resiliency against cybersecurity intrusions across the government, the public sector, and key industry partners, holding contractors and grantees to their commitments to protect government information and infrastructure, supporting government experts' efforts to timely identify, create, and publicize patches for vulnerabilities in commonly used information technology products and services, ensuring that companies that follow the rules and invest in meeting cybersecurity requirements are not at a competitive disadvantage, reimbursing the government and the taxpayers for the losses incurred when companies fail to satisfy their cybersecurity obligations, and finally, improving overall cybersecurity practices that will benefit the government, private users, and the American public. Now, utilizing the False Claims Act to pursue government contractors who fail to comply with federal cybersecurity procurement regulations is not new. In 2019, a federal district court in California ruled that a federal contractor's violation of cybersecurity requirements found in the DoD's Federal Acquisition Supplement, Clause 252-204-712, and NASA's acquisition regulations could form the basis of a key tam action brought by an employee under the False Claims Act. The name of that case was United States XRL Marcus versus Aerojet Rocketdyne Holdings. There are some key takeaways to this announcement. First, federal contractors should take notice. In light of the False Claims Act treble damages provisions and increased penalties of up to over $23,000 per claim, the False Claims Act provides strong incentives for relators to bring key TAMAT lawsuits on behalf of the government and collect their share of any recovery. Also, the federal government is clearly serious about pursuing false claims acts against federal contractors who fail to comply with cybersecurity requirements imposed by federal contracts and grants. In addition, federal contractors should remember that there are many sources of cybersecurity obligations for federal contractors, especially those who handle sensitive or classified information. And these obligations continue to evolve. For example, the newly revised Cybersecurity Model Maturity Certification Program in a podcast that we sent out earlier this week. Federal contractors should ensure compliance by maintaining business wide compliance systems to detect and remediate cybersecurity failures and timely report any breaches as required. And if you have any questions about this or need further assistance, please feel free to contact me at 757-446-8683 or email me at jgallo@vanblacklaw.com.